My name is Dimitris. I want to help the Common Good Foundation for its initiative to host such interesting voices this year's conference. Special thanks to Regina and Phil, who have coordinated everything so harmoniously so far. So, it's September, and I often reflect on my holiday 1 month ago, lying into some nice beach and playing with some crystal clear water. Apparently, my experience runs entirely opposite to the experience of this marine bird, drenched in the oil cargo generated by tanker Erica 21 years across the Brittany coast. The same holds for these Chinese female workers. There they are, dismantling tons of electronic waste with their bare hands, with no protective equipment. Probably the word holiday sounds something alien to them. After all, who knows what holiday means in a cancer village? Marine birds, Chinese female workers, cancer villages. Do they have a legal voice when it comes to their victimization in the course of waste operations? In my study, I explored institutionalized premises on the green victim identity in the waste sector. Who can qualify as an environmental victim in the waste sector? Under which circumstances does an entity claim or lose its victim status in the waste sector? In the first part of the presentation, I'm going to delineate some general theoretical insight that has up to this date informed the field of the green victim identity. In the second part of my presentation, I am going to apply this general theoretical insight into the institutional nexus governing waste operations in Greece, European Union, and the Council of Europe. Let me first start with the academic field essentially motivated my study, namely that of green victimology. It is not quite settled whether green victimology is a discipline in its own right, a sub-discipline under victimology, or just a theoretical framework. I'm mostly interested in its scholarly function. And this is to problematize institutionalized premises in the green victim identity and to bring forward an academic activism in our awareness of who can qualify as an environmental victim. Let me proceed with some basic premises permitting green victimology. So the first and most fundamental premise is a moral one. Both human beings and nature are of intrinsic worth. The second premise relates to the relationship between green victimology and environmental criminal law. And these, ladies and gentlemen, is a critical relationship. On the one hand, according to green victimology, all entities, regardless whether they are human or non-human, can qualify as environmental victims of environmental misconduct. By contrast, environmental criminal law opts for a more selective approach. That is, certain entities may qualify as environmental victims, and it is usually human beings who are granted an explicit victim label compared to non-human ones. And it is the selectivity that should problematize us, according to green victimologists, not least because it reflects some powerful alliances between states and corporations against environmental interests. At this stage, I made a step back and I essentially tried to make sense of this clash between the two approaches. And as I searched, it became clearer to me that this clash is rooted in a conflict between two broad philosophical frameworks on the relationship between human beings and nature. I'm talking here about anthropocentrism and ecocentrism. Let me briefly proceed into the basic premises that permeate each philosophical framework. So, the most basic premise in anthropocentrism is that human beings are morally superior to nature. Nature is stripped of any autonomous intrinsic worth. Instead, it is instrumental in the course of human interests. any form of environmental harm is essentially assessed against its impact on the human well-being. Anthropocentrism applies a managerial rationale when it comes to environmental harm. We cannot terminate environmental harm. We can only measure, quantify it, and refrain it within certain numerical boundaries. However, it would be unfair to overlook the fact that anthropocentrism is socially sensitized of the unequal distribution of environmental victimization across human groups on grounds of race, age, class, or cultural identity, to mention but a few. However, although this social sensitization is desirable, certain scholars still hold that it is predominantly fixed on the human well-being. Let me proceed with the premises permitting ecocentrism. And any premise of moral superiority of human beings over nature simply does not hold true here. Both human beings and nature, according to ecocentrism, are of intrinsic worth. Ecocentrism teaches us the lesson of interdependence between the two, meaning that any form of environmental harm engenders the harm of human beings, either in the short term or in the long term. Like anthropocentrism, ecocentrism is also sensitized of the unequal distribution of environmental victimization among human groups. However, ecocentrism expresses this sensitization under a different perspective. For ecocentrism, any form of asymmetry in environmental victimization is a direct consequence of anthropocentrism. That is, certain human groups are more likely to be environmentally victimized compared to others because they reside in overexploited ecosystems. I have just sketched anthropocentrism and ecocentrism in their ideal forms. However, our environmental laws and policies rarely classify as exclusively anthropocentric or ecocentric. Rather, they accommodate elements of both philosophical traditions and blend them in various arrangements. Let me now proceed into the more specific part of my presentation and see how the environmental victim identity plays out in the context of the waste sector. And I would like here to add some context about the structure of the waste sector, as well as its relationship with the environmental victim identity and phenomena of environmental victimization. The most important thing here is waste itself. Waste should be conceptualized as a product, a commodity that is traded in a transnational market, the waste market. And as with any market goes, there are certain services here that are of particular significance and circulate around waste itself, namely its recycling, storage, transportation, or disposal, to mention but a few. It is also noted that the most frequently met parties in this market are states and corporations. And I hope that by now it may be clear to you why green victimology has a stake in the regulations of the waste sector, not least because they reflect powerful alliances between states and corporations against environmental interests. Several research initiatives have featured the victimological aspects of the waste sector. For instance, there are studies that have featured the unequal distribution of environmental victimization across human groups, often on grounds of race, class, gender, or cultural identity. This was the case, for instance, with the location of waste incinerators and landfills nearby the headquarters of African American communities in the US, or with the location of waste landfills in the headquarters of indigenous communities. In the beginning of my study, I made an implicit reference to the overrepresentation of female workers in the electronic waste sector in countries like China and Vietnam. Arguably, women present a higher risk of being exposed to toxic chemicals emitted by the dismantling of electronic waste compared to men. But there are also studies that have portrayed nature directly victim of waste operations. This was the case with the Waikato River in New Zealand, as well as the contamination of soil in the course of waste operations in Croatia. However, it would be unfair to assume that our institutions have not tried to address the seriousness of the situation somehow. And nowadays, the governance of waste misconduct is not only a matter of criminal law, but administrative law and law provisions are now part of the game. What is more, governance of waste misconduct transcends the level of the nation state and reaches the regional and the international level of governance. That is, the governance of waste presents a multi-scalar approach. Last but not least, governance of waste misconduct is dispersed among public and private actors. That is, nowadays states, prosecution services, other official agencies with the competence in environmental issues heavily rely on private actors like environmental NGOs and environmental victims themselves to launch proceedings that hold waste pollutants accountable. So in my study, I tried to incorporate these institutional realities. I opted for a cross-jurisdictional framework that allows me to examine waste regulations in the national, regional, and international level of governance. In this respect, I chose the jurisdictions of Greece, European Union, and the Council of Europe. Overall, I examined 60 official texts, the majority of whom is legal in content. However, I also tried to incorporate some important soft law provisions as well as some significant policy documents in the field. Let me now pass into the findings. So as a general observation, the study reinforced the statement that environmental laws and practices hardly classify as exclusively anthropocentric or ecocentric. Rather, they take elements from both philosophical traditions and assemble them in various arrangements. And the study featured three main arrangements. First, a fragile coexistence between anthropocentric and ecocentric credentials in the field of the environmental victim identity. Secondly, a domination of anthropocentric credentials over ecocentric ones. And thirdly, a state of ambiguity between the two. Let me firstly start with the first arrangement, that of fragile coexistence. According to this arrangement, ecocentric credentials on the environmental victim identity are consistently disrupted by anthropocentric credentials. Let me illustrate my point with a textual fragment taken from the Directive on the Protection of the Environment through Criminal Law. Arguably, this textual fragment emanates an ecocentric rationale. Read, for instance, that member states shall criminalize waste operations that are likely to cause injury to any person or damage the quality of air, soil, water, animals, or plants. In other words, this textual fragment accommodates the interests of both human beings and nature as far as their victimization goes. However, its ecocentric rationale is disrupted, eroded by other textual fragments coexisting near this fragment and arguably permitted by an anthropocentric rationale. Let me draw your attention, for instance, to the Victims' Rights Directive, and its main premise reads that victim means a natural person. That is, even if our laws seem to take into account both the interests of both nature and human beings, the label of the victim is exclusively and explicitly reserved only for human beings, not for nature. And this disruption of ecocentric credentials is also prominent in legal standing provisions. For instance, we read here that, so in principle, harmful waste operations against nature or human beings can lead to litigation. However, human beings are explicitly granted a legal standing to address their victimization, to address their disprivileged position. In the Greek legislative framework, we read that the public means a natural person who, in the course of an environmental project, has the right to bring their claim before court. By contrast, the environment per se is not explicitly granted a legal arsenal to address its harm. We read that in environmental disasters related to waste operations, the environment per se is never represented in court cases. And let me once more draw your attention to this image, because I would argue it intuitively helps us understand the meaning of this arrangement. Like this glass of water, ecocentric credentials on the environmental victim identity are pushed towards the edge of the table by anthropocentric credentials, meaning that their establishment, their entrenchment in the examined institutions is rather fragile, precarious. Let me now move to the second arrangement. Here, the glass is definitely shattered. Here, I'm referring to anthropocentric domination over ecocentric credentials when it comes to the environmental victim identity. And this arrangement is particularly relevant as far as certain textual fragments are concerned, where environmental harm is essentially assessed against its impact on the human well-being. For damage affecting land, it is required that the land concerned be decontaminated until there is no longer any serious risk of negative impact on human health. In other words, the nature's health is of no institutional consideration. It passes unnoticed. But I would argue that the most profound case of anthropocentric domination is rooted in the realm of waste disposal. Here we read about practices like waste deposit into or onto land, or deep injection practices, namely the injection of waste into wells, salt domes, or naturally occurring repositories. In other words, our laws institutionalize the instrumentalization of nature. Here, the victimization of nature does not even exist as a possibility. Let me proceed into the third arrangement, that of an ambiguity between anthropocentric and ecocentric credentials. And I'm here interested into textual fragments that simultaneously echo anthropocentric and ecocentric credentials. So the first case relates to the unequal distribution of environmental victimization among certain human groups in the waste sector. And I have mentioned before that both anthropocentrism and ecocentrism have a stake in this sort of discrimination. We have also seen that this unequal distribution is sort of influenced by certain variables like class, gender, cultural identity. And the examining institutions seem to take certain variables into account as well. One of them is the occupational status, the fact certain people work in the waste sector, particularly the electronic waste sector, and thus are exposed to a higher risk of victimization compared to other human groups. There's also a sensitization as far as the age variable goes, and our institutions are sensitized of children labor in the course of waste operations. Let me now pass into the second case of ambiguity, and this relates to a paradox. Although certain legal provisions are driven, instructed by an anthropocentric rationale, in a somewhat perverse way, end up reinforcing ecocentric credentials. And this is the case with regulatory derogations and quantitatively driven understandings of environmental harm. Let me first start with regulatory derogations. Two things are of importance here. First, the examined institutions allow for zones where harmful waste operations are perfectly lawful. Secondly, in these exceptional zones, human beings are not granted any particular privilege compared to the environment. They both have to subdue under a necessary evil. And I would argue that this case latently equates human beings and the environment per se in the course of regulatory derogations. Actually, a fact that resonates ecocentric premises of equality between the two. So let me now pass into the quantitatively driven understandings of environmental harm, the second case of the paradox. And here I would like to argue this case relates a lot with the managerial rationale of anthropocentrism. The fact that that environmental harm in the waste sector cannot be terminated, but instead should be quantified and refined within certain numerical boundaries. So harmful waste operations that exceed these numerical boundaries are illegal and should be criminalized as such. But harmful waste operations that do not exceed these boundaries are perfectly lawful. And in this regard, our institutions put particular emphasis to obvious, like large-scale indicators of harm. By contrast, low-risk harm indicators in the waste sector, which may present a long-term risk for our ecosystems, pass relatively unnoticed. Once again, in these perfectly lawful numerical margins, both human beings and the environment are equated de facto in the same position. Human beings are not granted any particular privilege compared to nature. They both have to be exposed in the same long-term victimization risk. And I would argue that this case of anthropocentric managerialism reinforces the basic premise of interdependence that ecocentrism teaches us. Let me now all this up. Who qualifies as a victim in the waste sector across Greece, the European Union, and the Council of Europe? I would like, so first and foremost, human beings unequivocally qualify as environmental victims in the waste sector. Additionally, the exam institutions seem to take into account that certain human groups are more likely compared to others to be environmentally victimized in the waste sector, with the variables of occupational status, age featuring as the most important ones. Thirdly, the environment per se, nature, enjoys a rather tentative, if not undermined, victim status in the examined institutions. Last but not least, in certain circumstances, the examined institutions latently reproduce ecocentric premises in terms of the interdependence of victimological capability of both human beings and nature. I would like to thank you for your attention.